We're here with the exact notice that landlords need to give to terminate a tenancy in 60 days in California. But don't worry, this is a guide for tenants and landlords. Hey there, Christian Walsh, Coldwell Banker, Wire Associates. We're real estate brokers based in Southern California who specialize in helping tenants and landlords and buyers and sellers in California and beyond. We're here to cover one of the most common questions I get, and that is, where can I find a copy of the notice to terminate a tenancy or to get my tenants out in 60 days? We are going to run through the exact notice from the California Association of Realtors that a landlord can use under SB 91 to give a 60-day notice. So why is this a guide for landlords and tenants? This sounds like it's just for landlords. No, the truth is tenants need to know what makes up a legal notice in the state of California and what is allowed under SB 91. So this is a great way for you to learn and make sure if you receive a piece of paper that it's the proper notice for you. Now, of course, I've said it before, I'll say it again. I can't give tax or legal advice. So you need to run everything by the appropriate professional. For tenants, it'll be reaching out to legal aid or lawhelp.org. For landlords, you can turn to your local apartment association to find an eviction specialist. This is also helpful for landlords to see if they can give a notice to terminate a tenancy. It has to follow within the few narrow guidelines of SB 91. Otherwise, it's not a valid notice to terminate tenancy. Another big important point, just because you want to sell a property, landlord, you can't give a 60-day notice. There has to be specific reasons to terminate the tenancy, and we're going to go through those in this video. By the way, if you're looking for the most up-to-date coverage for tenants and landlords, make sure you subscribe to this channel. So having said that, if you're ready, hit that like button and let's dive in. And away we go. Here's the form that lots of folks have been asking for. We're about to dive into it. An important first point is this is the form as of shooting this video. The form could change dramatically in the next couple weeks or months, but just be sure that you're using the appropriate form. Now, theoretically, this form will be good through June 30th, 2021, but you never know, things can change. And then your other question is going to be, where can you get a copy of this form, landlords will ask. So the short answer is, if you're working with a realtor who's willing to give the form to you because you have a working relationship, that's one route to go, because this is the California Association of Realtors version. Property managers may also have access to this version of the form. The other place would be a local apartment association. They're going to have their own versions of forms like these, and that is what you'll use. Don't forget, I can't give tax or legal advice, so you are going to have to run this by the appropriate professional and use whatever form your attorney tells you to use. Okay, so don't forget that. I may have mentioned once or twice, I can't give legal advice. So let's dive in. So this is the form, and this one's actually brand new because what it does is it reflects SB 91, which was just passed. The last form had the deadlines from AB 3088, and now this one obviously is in the era of SB 91, and up at the top it says up till June 30th, 2021 for terminating tenancies. So at the basic stuff at the top, it's to the tenant and the address of the apartment. But then it gets into the important items. And what it's talking about here is AB 1482, the Tenant Protection Act of 2019. We've done plenty of content on that. I encourage you to find that. What it did is, when this passed and went into effect, it put in place just cause provisions. Before, you could essentially ask a tenant to leave for any possible reason, with appropriate notice. You didn't have to give a reason. So along comes AB 1482 and changes that. What AB 3088 and SB 91 have done is they've expanded the properties covered under AB 1482. So that's why this section is talking about the Tenant Protection Act. So here we go. This is where the rubber meets the road, because this is, according to SB 91, these are the few reasons that you can terminate a tenancy during COVID. through July 1st, 2021. And we've discussed these in our other videos, but here it is in black and white. You can download a sample copy of this form. I'll have a link below so that you can look closer. But let's go through real fast. So it's a 60-day termination, or it could be longer. You could deliver this, it could be 90 days. So 60 days minimum. So A would be family move-in. So this would be the owner, a spouse, partner, parents, grandparents, children, grandchildren. That straight line. If they're moving in and intend to occupy the premise, then a landlord can terminate a tenancy. But there's an important caveat here. You'll see it mentions Form RCJC, and we're going to talk about what that form is. But that's required in many cases that the landlord has given that form. The next one is owner intends to withdraw the premises from the rental market. And we've talked about this in some of our other videos, including the most recent SB 91 video. This to me is a very weak approach for a landlord to take to terminate a tenancy. If the tenant doesn't move out and it goes to unlawful detainer, I can't give legal advice, but my guess is that many judges will try to pierce this and want a pretty darn good reason that you are removing it from the rental market. And it can't be because the tenant hasn't paid rent. That's not why. That's not a valid excuse. Next, and we talked about this in SB 91 video, the owner intends to demolish or substantially remodel the premises. But what SB 91 says is it has to be due to habitability or a court order. And that's essentially what D is saying, that a court order or government agency is saying you have to demolish or remodel it. So that can't be just to spruce it up, landlords. You really have to be taking care of habitability. And you have to pull permits, and it has to essentially take longer than 30 days. Those are some of the tests that a judge may use. It's kind of a double-edged sword to me, because if you're letting your tenants live in a unit that's not habitable, this could open up other problems. So that's why I say it's a double-edged sword. So again, consult with your legal counsel on this one. And then the final one, and this is essentially the biggest loophole for SB 91, but it's a very tight one, and that is the owner's entered into a contract to sell the property. The buyer is going to move in, and the property is essentially a single-family home or a condo. This technically won't work for duplexes or bigger. And it also mentions that this form, the RCJC form, needs to be delivered. And we're going to talk about that one. Like I said, that's a form that needs to go out. So the other important thing it mentions is that if the landlord is terminating the tenancy through one of these, and the landlord would owe relocation assistance under AB 1482, that the landlord still owes that. But if it's an exempt property, it's exempt from that requirement to pay relocation. The landlord does not have to pay it now. So, and I did other content that explains what that means as far as exempt. The other big category you could check, and again, I can't give legal advice, but I don't recommend going this route. This is very similar to E, in fact, almost identical, but it's a 30-day notice, and it also says that the tenant has not been given a notice of termination of tenancy in the past. I would say it would be safer if you were to go with the 60-day notice. Even though this form says you can do it in 30, I'd say it's safer to go to 60. And it's better for the tenant, gives them more time. Okay, another very, very important thing that's on this form, and this is section 1946 from the Civil Code, and it is right here, this section related to personal property. So make sure every notice to terminate tenancy must have this language, or the notice will be null and void and the landlord will have to start over. So if you're using an old form in your filing cabinet that doesn't specify the reason for termination, those boxes we just went through, you need to check a box, landlord. So that's one important thing. The other important thing is it has to have this on the form. And some people still have these sitting around, and I did a video where I Googled forms today that don't have the right language on there. So that's very important. If they're missing this, it's a null and void notice. So landlords, make sure it has that. And I said this was a guide for tenants and landlords. So tenants, there's a great loophole for you. If that's not on there, then that notice is not valid. Okay. Then this form runs through some other stuff that basically, if it's an at-fault reason to terminate tenancy, related to default in the payment of rent as long as it's not due to COVID-19, or something else is going on, such as waste or too many people living in the unit, subleasing, etc. It tells really what what needs to happen to terminate those tenancies. And then, so the landlord signs that. Then there's one more important page to this, and you'll find this on other notices as well from the apartment associations. This is for delivery of notice and proof of service. So this is the other important part of the notice, is actually properly delivering the notice. And we're gonna do additional content on this, but just to run through it real fast, the important thing is, there's an order. So what you try to do is start at the top and work your way down. The most preferred order is personal service. And what that means is you or a representative hand it directly to the tenant mentioned on the notice. So that would be number one. Substituted service would be number two, and that would be basically you give it to somebody who's 18 or over at the property who isn't one of the tenants mentioned. Then the other route you can go is post and mail, and that would be you hang it from the door and then you mail a copy. And then you can also serve by certified or registered mail, but that adds some additional time to the notice because it has to get to them. So that's the order of preference. We'll do more content on that, but that's just as important for a notice as it has to be delivered correctly. So the other form we mentioned, the rent cap and just cause addendum. So that's what RCJC stands for. That's what the California Association of Realtors calls the form. There isn't, like, you won't find RCJC necessarily anywhere else. That's not the legal name of the form. That's the name that the Association of Realtors has given it. And this form is specifically related to AB 1482. So SB 91, AB 3088 expanded AB 1482. That's what happened. So that's why this is part of it. So it's important that landlords give this to their tenants, and it mentions whether the property is exempt. You can see you check a box if it's exempt. This is a form that's required for landlords to give. After July of 2020, they were supposed to give this form to every tenant if there's any new lease or renewing a lease. But a lot of landlords using old leases don't have this correct language in there. So, and this form goes in depth. Again, I'll have a copy you can download below. You can read more on no fault and at fault. But this would be an important form to deliver before giving the notice to terminate tenancy for those few examples I mentioned before, where a relative's going to move in or the owner's going to move in, or you're going to terminate it because the property is under contract. If you use the California Association of Realtors notice I just referenced, it will need to have, let's go back up so you can see, it'll need to have the RCJC. You're going to have to include AB 1482 language. So for A and E, you need to include that form. So landlords, get that to your tenants. Tenants, this was a guide for you so you can see the loopholes. If your landlord's not following the law and you didn't get some of this stuff, then you've got a way out from notices. We know we covered a lot of ground, took a long time, and going through forms is like watching paint dry, but this was very helpful. We showed landlords and tenants what is necessary for a proper notice. Of course, run it by an attorney first. So if you're looking for more coverage like this about important topics for tenants and landlords, make sure you subscribe to this channel. Any additional questions you have or topics you'd like covered, make sure you leave a comment below. We also have a free weekly email newsletter that you can subscribe to below. Comes out on Sundays, and it covers more topics like this, as well as foreclosures, market updates, and more. We'd love to have you subscribe. So thanks for tuning in. This has been Christian Walsh, Coldwell Banker Wire Associates, and we appreciate you.